Hi and good afternoon, everyone, and welcome to our first webinar of 2022. It's great to be back after a little bit of a festive break. If it's not too late, Happy New Year, everyone. I'm Anna and from the TUC, and we'll be talking today about flexible working and what rights you have and what rights you have to represent your members when it comes to flexible working. We've got two fantastic speakers. We've got Jo Seery from Thompsons Solicitors, who'll be talking about the law in this area, and my colleague Alice Arkwright will be talking about the union position on these issues. But we'll get to them in a second. Our usual housekeeping, we have live captions on this webinar, and there's a green button at the bottom of the screen that says Open Live Transcript. Please click on that to view the captions for the webinar. We will try to answer as many questions as we can after presentations from Jo and Alice, and there's an Ask a Question button right at the bottom of the screen. Please post your questions there. It's great to see you all introducing yourselves in the chat panel on the right hand side, but can you also please use the chat panel to tell us about your workplaces, whether you've got flexible working arrangements, be they formal or informal, or any experience you've got in these areas. It's always great to hear what's going on in workplaces. So first of all, what is flexible working? We're hearing this term a lot at the moment, and it's very broad. It doesn't just mean people working from home. It includes lots of other changes in either location of work or in hours of work. So some examples of flexible working, as I've said, include work from home. They might be compressed hours. So where someone might work a 5-day week, they change to make the same number of hours over 4 days. It might be term time only working and not in school holidays. It might be flexi time. It might be a job share, and it might be part-time working. For people who work shifts, flexible working would mean predictable shifts. So this might be a mutually agreed schedule, perhaps with 4 weeks notice for that individual who does work shifts. So that's just to set the scene, to remind us all what we're thinking about when we talk about flexible working. But for now, I'm going to hand over to Jo from Thompsons to talk us through the legal rights to flexible work. So Jo, over to you.
Great, thanks very much. I'm really pleased to be able to speak to, wow, so many people. You can't normally do this in one room, can you? So it's fantastic to see so many people turn up for this. But as you've said, you know, it really is a hot topic, but it has always been a hot topic for unions. I feel like the government's kind of like hijacked the agenda a bit, really, talking about flexible working and trying to be all positive about it, because it really has been high on the union's agenda. And that's all forms of flexible working for quite a long time. And this is, as we will see, despite the legislation, because I have been given the poison chalice of going through the statutory provisions on flexible working, which, as you will see, are quite limited. So I'll start off by going through those statutory rights, and then what I will do is look at some of the other rights that maybe you as union reps and union members may better support you in your applications for flexible working. So you've already said what is flexible working. In terms of the statutory rights, the most important thing to remember is that the statutory right is a right to request flexible working. It's not a right to be given flexible working. It's not even an obligation on an employer to grant a flexible working request. It really is just a right to request flexible working. So who does the right to request apply to? Well, it applies to employees who have got 26 weeks continuous service. So it doesn't apply to workers who make up a large proportion of the workforce, and it doesn't apply to the self-employed, nor does it apply to agency workers. So you can see right away that the statutory right is quite limited. What flexible working can be requested? Well, if we look at this is defined quite broadly, in broad terms, really. An employee can request a change to their hours of work, to the times that the employee is required to work, and a change to the place where they work. And obviously the focus has been on the latter as a result of enforced home working. But there are these other provisions, as I say, a change to the times worked and hours worked. And the important thing there is also to note that there is no obligation on the employer to change a person's actual job. So the flexible working is limited to the flexible working related to the employee's particular job, not to give them an alternative job. It doesn't go that far. So given that the statutory right is a right to request, how do you make that request? Well, the law is pretty prescriptive in this matter, and it's important that all points are followed. So the application must, first of all, be in writing and dated. It must state that it is an application under the statutory procedure. So it must state that I'm making a flexible working request under the statutory right to make a flexible working request, and this is set out in section 80F of the Employment Rights Act 1996. It doesn't necessarily have to say that, but it does have to say that it's a statutory right. I'm just letting you know what the statutory provision is. Third, it must specify the change applied for. So it must set out what flexible working you're requesting. Is it a request to work part-time? Is it a request to have a later start time and an earlier finish time? Is it a request to change from flexible shifts to fixed shifts, or from fixed shifts to flexible shifts? That kind of thing. So it must set out exactly what the flexible working is requested. It must also explain the effect, if any, on an employer and how it might be dealt with. So this is kind of like anticipating why the employer might refuse a request for flexible working. So, for example, if somebody is requesting a job share, you don't hear that quite as much now, but if somebody is requesting a job share and they know that somebody else is available, would be interested in sharing the job with them and doing the same job, etc., then you could say, well, there is somebody else interested in doing the job share as part of the effect, and that therefore there will be a minimal effect on the employer because there is already somebody else willing to do it and it won't affect the business, for example. In other cases, it might just be a simple, straightforward, there won't be any effect on the business. And that's probably the safest option to go for, rather than trying to anticipate what the employer says. And then they must also set out whether they have made an application before. And this is important because the statutory right to flexible working only applies once in 12 months. So an employee can only request flexible working once in a 12-month period. It's very, very important that all the 5 points are included in the application, because otherwise the application will be treated as invalid. So it's got to be in writing, dated, state it's made under the statutory procedure, state the flexible working that's being requested, explain any effect on the employer and whether or not they've made an application before. All those points must be covered. Otherwise, as I say, the employer will say, well, the application is invalid. Now, that might be a good or a bad thing, and we can come on to look at that shortly. Now, how must the employer deal with the request? So once you've put in your request and you've complied with all the statutory provisions, what is the obligation on the employer then? Well, in contrast to what we've seen are quite prescriptive requirements when an employee makes a request, there are rather broad provisions on how the employer must deal with the request. And you won't be surprised to find that the obligation on the employer is to deal with the request in a reasonable manner. Now, we see reasonable pop up all the time in employment law, and what we think is reasonable is not necessarily what the employers think is reasonable. So here there is some supporting guidance that unions can rely on, because there is the ACAS Code of Practice, and that is higher than guidance and must be taken into account by an employment tribunal. So if you do get to an employment tribunal under the statutory procedure, then the Employment Tribunal can take into account what the ACAS code states. So in terms of dealing with a request in a reasonable manner, the ACAS code states that employers should discuss the request with the employee. So they should arrange to speak to them at least, or arrange a meeting. There's no obligation on the employer to have a meeting, but they should at least, as in accordance with the ACAS code, arrange to speak with the employee. And although there isn't a statutory right to be accompanied at, say, a meeting where that might be online or over the phone with the employer about an employee's request, the ACAS guidance does recommend that employees have a right to be accompanied. As I say, there's no statutory obligation on them to do that, but it's something that ACAS recommends in the code, and an employment tribunal could take that into account. The employer, to act reasonably, must consider the request carefully. So what does that mean? Well, ACAS says that means that the employer's got to look at the benefits for the employee and weigh those up against the adverse impact on the business. Now, some of you will be aware that the government have carried out a consultation on making flexible working the default. And in that, there's some quite useful information for unions to refer to when they're negotiating with employers. One in particular talks about the benefits to the employer of flexible working. It states that, for example, that flexible working fosters a more diverse workforce, and there is some evidence from the McKinsey report that shows that there are financial benefits for the employer. So when acting in a reasonable manner, you might want to put this guidance in front of the consultation, in front of the employer's nose, to show that there are benefits to the employer as well. And thirdly, the ACAS code says that dealing with a request in a reasonable manner means that employers must deal with them promptly. Now, there is a limit anyway in terms of how long the employer's got to deal with a request. The statutory provision says that the employer has got to notify the employee of their decision, and that includes if there is an appeal against the employer's outcome, 3 months of the date that the application was made, unless both parties agree to an extension. And there is a recent case which held that where an appeal against an employer's decision not to grant the flexible working request was held outside of the 3-month period, and there had been no agreement to extend that period, the tribunal said, well, the fact that the appeal is outside the 3-month period and the employee is going to turn up to it doesn't necessarily mean that they agreed to the extension, and the employer in that case was held to have failed to comply with the statutory procedure for flexible working. So you've got your request in, you've complied with that onerous statutory requirements, the employer's complied with its obligations insofar as it's concerned. If the employer grants the request, then generally this will be an agreement to vary the terms of the contract, and that will usually be on a permanent basis unless the parties specifically agree that this is temporary. So if it's not permanent, you can't just assume it's temporary. You must make that part of any agreement. And it's quite curious, really, because the legislation doesn't prescribe that any agreement on flexible working should be set in writing, but you would, of course, expect us to advise that make sure you get any agreement on flexible working in writing, because it will be important for you to rely on that later on, especially if it's a permanent change, in which case it will be a variation to your terms and conditions, and it will be important to get a variation in writing where the parties agree to it. If it's a temporary variation, then similarly, it must be in writing to show that it's temporary and set out. We would suggest that it's set out quite when that temporary period ends, quite prescriptively. So turning to the more common example is where the employer refuses a request. And there are fairly extensive reasons for why an employer can refuse a request. And these are set out in the legislation. So this is quite unusual for legislation, really, to give a shopping list of reasons. But given that these are reasons that the employer is relying on, perhaps we're not that surprised. The most cynical amongst us might be thinking that. So the business reasons an employer can rely on include saying, well, we've refused because of the burden of additional costs, because there is a detrimental effect on ability to meet customer demand, there's an inability to reorganise work amongst existing staff, we're unable to recruit additional staff, there will be a detrimental impact on the quality and performance of the business, or there's insufficient work for the employee to do during the periods when they say that the employee wants to work as part of a flexible working request. So you can see, I mean, this is a broad range of options for the employer. It gives them plenty to rely on to refuse a request. And as I say, they're fairly extensive. So faced with the rather disappointing, to say the least, statutory provisions and the options for the employer to refuse a request, I think we have to look at other legislation, other statutory employment rights that workers can use to support a request for flexible working, or to challenge employers who refuse a request. So, you know, an employer who refuses a statutory request, that isn't necessarily the end of the matter. So a refusal could be indirectly discriminatory. So, for example, if a woman requests to work fixed shifts or because of childcaring responsibilities, and this is refused because the employer has a flexible shift pattern, the employer is effectively applying a requirement that the employee works flexible shifts, and that puts her at a particular disadvantage because she's unable to arrange a childcare, for example, so she might not know when she's required to work. So that might give rise to a claim for indirect discrimination, but it is still open for the employer to justify that discrimination. And although it might be similar in some respects, because employers are inevitably going to rely on a business reason as a legitimate aim for justifying the discrimination, a discrimination claim will scrutinise that argument much more closely than they will in a flexible working request, refusing a flexible working request. In particular, the employer cannot just rely on a business reason as a legitimate aim. It will need to be able to show that the discrimination was proportionate and consider whether or not there are less discriminatory measures. So if the flexible working that the workers requested, that the employees requested, has been refused, is there an alternative? So there is one example of a case, but I'm conscious of the time here of me speaking, but there is a quite a good case. This is only an employment tribunal case where the employee put in a request to work 2 days a week and 1 day from home, and they were refused on the basis that a job share wouldn't work. And the employment tribunal in that case found that it was indirectly discriminatory because the employer hadn't actually considered whether a job share could work in the workplace. There was evidence to show that the job that the employee did was popular and that there were other employees who might want to work a similar working pattern, and that the job was capable of being done by 2 employees, and the employer had failed to consider alternatives. So there's a bit more scope to negotiate on what a justification defence is, and you can put the employer to task to say, well, what alternatives have they considered? And that's the main point from that. The other option, of course, is if a worker has a disability, it might also be possible to argue that a failure to grant a flexible working request, such as a request to work from home, amounts to a failure to make reasonable adjustments. Now, the law on making a failure to make a reasonable adjustments prescribes that an employer is under a duty to make a reasonable adjustment for disabled workers who fall within the definition of having a disability under the Equality Act, where a provision, criterion or practice a physical feature or a failure to provide an auxiliary aid puts a disabled worker at a substantial disadvantage in comparison to those who are not disabled. So it doesn't mean that the employer has to grant a disabled worker's request. They have to see whether or not that request would have the prospect of removing the disadvantage. So if the employer gave the worker a later start time, for example, say for a disabled worker who has colitis, then would a later start time remove the risk of that disabled worker being disciplined or dismissed? Yes, it would. But that might not be the case in relation to another flexible working request. So the important thing is does the request for flexible working have the prospect of removing the disadvantage for the disabled worker? So just to conclude then, the grounds for bringing in an employment tribunal claim under the statutory flexible working provisions are, as we have seen, pretty limited. There's wide scope for an employer to refuse it, and there are onerous obligations on the individual in terms of only being able to make a flexible request once within a 12-month period. And things, as we have seen, have been fast moving and changing all the time. The ability to bring a legal claim is limited to an employer's failure to deal with a request in a reasonable manner, failing to make a decision within a decision period, or refusing a request on incorrect facts. So an employment tribunal won't investigate the employer's business reasons or their commercial reasons. They will just consider whether or not there are some incorrect facts in what has been considered by the employer. And again, the time limits are really tight. So you have to submit a claim within 3 months less 1 day of the employer's decision. There are alternatives in terms of the discrimination claims that we've looked at. So the time limit is 3 months less 1 day from the act or the last act or the last in a series. And the remedy is slightly better in a discrimination claim because an employment tribunal can award compensation and it is not capped. That doesn't mean to say that people will be awarded hundreds of thousands of pounds. The evidence shows that that's not necessarily the case, but individuals can claim injury to feeling awards as well as any lost earnings as a result of it. So there are some options legally that can be done, not necessarily within the statutory flexible working regime, but I think ultimately it's better if unions can often get a much better result negotiating flexible working collective agreements with the employer. We've seen amendments to Agenda for Change, for example, which have resulted in improvements to the flexible working provisions. And also, unions have been really canny and really inventive in how they've approached the whole issue of COVID right at the start, prior to when we were really secure about the furlough agreement, for example, and the furlough provisions. Obviously, that was negotiated with the unions. That's a form of flexible working, if you like. But also unions were able to negotiate a lot of more flexible working arrangements as part of a way of stemming the tide where employers sought to just dismiss people for redundancy. And I think Alice is going to talk about that. So I'll stop treading on your toes, Alice, and hand over. So thanks very much.
Thanks, Jo. You've covered so many of the legal points there, which has been fantastic. And you've probably seen we've had a lot of questions come in. I'm trying to group them so that we cover as many points as possible. But before we go to questions, we're going to hear from Alice talking about the union and the TUC position on this. So over to you.
Hi, everyone. My name's Alice, and thank you, Jo, for such an incredibly detailed introduction to all the legislation. I was going to talk a bit about kind of the opportunity to negotiate collective agreements on flexible working. As Jo has kind of demonstrated, the law around flexible working is pretty poor in terms of what individuals are able to get. So it is a real opportunity for reps to negotiate above that and get a collective agreement on flexible working that works better for your members. I've been looking at the chat slightly and just loads of examples of people's requests getting rejected. So an opportunity to collectivize the issue. I was going to speak, first of all, just a little bit of run through some ideas that can be included in collective agreements and policies on flexible working. Most of these are taken from existing policies that we've seen that affiliates have shared with the TUC, and then talk a little bit about home working and hybrid working, just some specific points around that might want to be considered in a negotiation, just because I know that is something that a lot of employers are looking at the moment. And obviously with the announcement to end work from home guidance this week, a lot of workers, many but not all workers, will kind of want the opportunity to continue some elements of work from home into the future. So just two introductory points I wanted to make were kind of, as Jo and Anna have both said, flexible working can include a huge number of different options in terms of variations to where you work, but also hours of work. Workers are best placed to understand what flexible working options work for them and work within their roles. And whilst not every type of flexible working will work in every job, I do think that every job can accommodate at least one form of flexible working that is of benefit to the worker. And just wanted to point out as well that kind of legislation, when it was first created, was originally focused on parents and carers, and often flexible working is associated with parents in particular. It is really, really important for parents to get access to flexible working in order for them to be able to work, especially for working mums. But just wanted to highlight it has huge benefits for loads of different workers. For example, older workers may choose phased retirement options, which can be a form of flexible working. Women going through the menopause, for example, often request flexible working as a way to help manage their symptoms. As we've discussed, it can be a reasonable adjustment. We've also heard from affiliates around how varying work hours can help survivors of domestic abuse if their abuser attempts to turn up at their workplace. And it can allow people time to kind of learn and volunteer alongside working and generally improve work-life balance. So there's a whole host of benefits for workers in connection to flexible working. But despite all of these benefits, as we've heard from Jo, there's kind of huge problems with the current system. And the individualistic kind of right to request model often means that flexible working is kind of framed as a perk for a favoured few, or it often carries kind of stigma or negative treatment for those people who do work flexibly. So what the TUC aim and the kind of union view is, we want to shift from this right to request model to make flexible working a more normal and more default way of working that everyone has access to. And in principle, we think the best way of doing this is to have a kind of role-based approach where employers with unions evaluate roles for what flexible working is possible, then can be accommodated in a role. This would mean that everyone can share the benefits, everyone will be able to understand what flexibility is possible in their role. And the individual system at the moment can sometimes create tension between two workers where two individual requests don't quite kind of match up with each other. So having a more collective approach can help to address some of those tensions. So I was just going to quickly run through some kind of suggestions for what to ask for in a collective negotiation. So when looking at a flexible working policy, a kind of first general point is make sure it's for everyone. So any flexible working policy should include a range of options for everyone and for every role. So for example, if you're looking in a healthcare setting, like admin staff may be able to benefit from home working, but that's probably not going to work for clinical staff who may want more things like a job share or set shift patterns. So it's important that the policy encompasses all the different types of roles that are available within your workplace. Thinking about recruitment is really important as well, and job adverts. So we're campaigning at the moment for the government to make it law that employees have to advertise possible flexible working options in job adverts so that people know the flexibility, what flexibility is possible before they apply for a job, and then they can take up that flexibility when they start. This is obviously a big shift from an individual request to the onus being on an employer to make it transparent. And this kind of, we know that many people don't feel comfortable asking for flexible working for fear of being turned down, which kind of, as Jo explained, is very common, or for receiving negative treatment as a result of asking for flexible working. And that's especially true when it comes to asking in a job interview. So we know that many people would feel extremely uncomfortable asking for any sort of flexible working in a job interview. And chances are they end up taking a job that then can't accommodate the caring requirements or other factors they need. And we'll only find out kind of 26 weeks down the line when they're able to make that request. So the kind of putting flexibility in job adverts is something employers can start doing. They don't need to wait for a change in the law. And obviously reps and unions should be involved with reviewing jobs to understand what's possible, what flexible working options are possible. As Jo said, there are lots of benefits to employers when it comes to flexible working. And just looking at the recruitment element, we know, for example, working mums are far more likely to apply for a job if it included flexible working options in the adverts. So a benefit of moving to this model is employers may possibly see an increase in the number of applicants they're getting, but also a diversification of the people who are applying. It also might reduce the requests that employers get further on down the line if people already know upfront in a job what they're going into, what flexibility they could get. When making updates to a policy in relation to kind of how individuals can request, lots of stuff we've seen in different policies, and some is similar to what's included in the ACAS Code of Practice, is, for example, including provisions so that everyone is able to ask for flexible working and you don't have to wait for that 26 weeks. To increase the number of requests that Start can make every year rather than limiting it to just one. I can see we've had a question come through about what to do if you do need to make another request within a 12-month period. And workers are very limited at the moment, so getting that win in a policy can be extremely beneficial. Other provisions we've seen are extending flexible working rights to everyone, not just employees within your workplace, requiring your employer to respond more quickly to requests than the legal 3-month window, introducing an appeals process. It's not a statutory right at the moment that you would be able to appeal your employer's decision, and include the opportunity to meet and discuss a flexible working request with your employer with your rep present. In terms of addressing the very broad reasons that employers can reject a flexible working request, it might be helpful to put in a policy a statement around a kind of positive presumption to a request for flexible working, unless there is a kind of clear business need as to otherwise. And there may also be benefits for kind of asking for review periods when people do make flexible working requests, so that people have the opportunity to potentially go back to the previous terms and conditions they were on, just in case the flexible working option isn't working for them. And as Jo said, kind of putting in temporary responses or permanent requests, depending on what members need. Putting in review periods is just worth flagging. It will kind of depend on your workplace whether you think this would happen, but putting in a review period could open up the opportunity for an employer to backtrack on a decision they've made. So just worth bearing that in mind. I just wanted to touch a bit as well as kind of, I mentioned that a lot of flexible workers do experience stigma when they start working flexibly. Our research has shown that we did a survey of working mums, and 86% of those who worked flexibly said they had experienced disadvantage and discrimination kind of as a direct result of working flexibly. So there may be some elements in your policy you want to consider to address the stigma or negative treatment that people might experience and to prevent discrimination. So, for example, requiring of employers to monitor flexible working requests and responses to them, but then also monitor things like progression, pay, access to training, disciplinary and grievances of flexible workers, and comparing that to those who haven't got flexible working options. will potentially highlight if there are issues in the way that flexible workers are being treated. And a kind of obvious thing to focus on is that the terms and conditions of flexible workers outside of their flexible working shouldn't be any worse than those who are not working flexibly. We've seen threats from employers to cut pay of people who want to stay working from home and things like that. Training for managers in how to manage flexible workers is also key. And the potential for a provision around victimisation in any flexible working policy could be helpful, and probably a kind of policy, a section of policy you have written elsewhere in your workplace policies. As Jo said, often flexible working requests are related to protected characteristics. So poor treatment of someone working flexibly could amount to victimisation. So you might want to consider kind of addressing that in any workplace policy. Sorry, that was a huge rapid run through of lots of different ideas, but I was also just going to talk a bit about home working and hybrid working, given that we know it's a kind of area that lots of employers are looking at the moment. We've also worked with the Flexible Working Task Force, which is a group of organisations, to put together some guidance around hybrid working, so I can share that in the chat, and I think it will be emailed out afterwards. I mean, I think a first point of principle, which is what reps would apply to obviously any policy negotiation, is surveying and speaking to members. And I think in this particular instance, people will have learnt so many lessons from how they've worked at home over the past 2 years that it's essential that your employer puts in mechanisms for people to be able to kind of feed back on those experiences and influence the design of any hybrid working policy. Wanted to flag as well that many employers might be inclined to put in blanket approaches. So, for example, everyone needs to come back in 5 days a week. They might try to force everyone, or kind of say everyone has to be in a 3-day-a-week process with 2 days a week kind of back at home if that's the option. The issue is if blanket policies are applied without any options for additional flexibility, this may be inadvertently disadvantaging some groups or amount to direct and indirect discrimination. So, for example, if a disabled worker has shown they work successfully from home during the pandemic, and this is withdrawn by the employer because they have put in a blanket policy without any flexibility within it, that could be a case of discrimination. We've also seen a kind of recent tribunal case, which I can also share a link to. And in this case, the blanket policy referred to hours. So there were set hours of kind of 9 to 6 working, and a mother had their flexible working request denied to finish early and work a 4-day week. And the tribunal ruled in her favour. And it was a kind of example of where a tribunal has been willing to rule against a blanket policy that put a woman at a disadvantage because of her protected characteristics. So it's just something to bear in mind when looking at hybrid work policies. Just another few points that want to be considered when looking at home working is kind of additional training for managers around things like communication, collaboration, how to manage remotely, and important points about supporting well-being when people kind of are working at home. I mean, as we've touched on already, working from home can be a reasonable adjustment itself, but employers are still under a duty to provide any other reasonable adjustments to workers who are working from home. Those same duties apply regardless of where people are working. Communication and encouragement of employers to set up mechanisms so that people who are working from home are not cut out of key decisions or conversations about work. Obviously, new technology can be hugely helpful in achieving this. There's also elements about clear work-life boundaries. There is some evidence of an increase in working hours for people who work from home. So policies may want to address this through things like a right to disconnect policy and elements to be able to keep an eye on workloads. I think there was a previous webinar just before Christmas about AI in the workplace, and kind of one of the things that has been flagged is the potential for monitoring and surveillance of employers to extend into people's homes, which could be unlawful. I'm sure that webinar probably touched on it in a lot more detail than I can, and I know we've got some guidance around it which can be shared. Some final points, just again, costs of home working. We know that home working can increase the costs of people's internet bills, heating bills, and wear and tear of personal equipment. So employers should be making sure that workers aren't out of pocket for any of these costs. A common argument from employers we're hearing is that people are saving money on travel, but in some instances, the cost of working from home may cost more than this, and many people who are working in a hybrid way might lose the benefits of a travel card, for example, which allows them to save that money. Linked to that, obviously, employers should be providing the correct equipment so that people are able to work from home successfully and be able to do their jobs. And employers are still responsible for the health and safety of those working from home and should be conducting risk assessments with health and safety reps. And again, I know TC Ed have got some really good guidance around conducting risk assessments in the home, which can be shared. So sorry, I just wanted to end on the point as well that kind of a lot of those things show that there are potential risks from working from home in terms of increased isolation or lack of communication and things like that. But what we do know is that access to home working, as well as other forms of flexible working, means that working mums, disabled workers, lots of other groups have access to workplaces and makes it easier for them to kind of stay in work. So there's a responsibility on employers to make sure that people working from home have a kind of equitable experience as those based in a workplace, and don't experience disadvantage as a result of working from home. That was sorry, I feel like I've been talking for absolutely ages, so I'll end on that point. So we've got time to get through some questions.
Thanks, Alice. Like Jo, you've given us a fantastic overview of the union position on this. And I think what's key for the audience to remember is Jo outlined the legal minimums, but as with all issues when reps are negotiating in the workplace, remember the law's the minimum and we should always be trying to get more than that. And the law serves as sort of, the base, as Jo said, there's a lot of areas for improvement, but until the law changes, what we can improve on is the negotiations, if we're able, that we can negotiate. Right, we've had a lot of questions, so I've tried to group them so that we can cover as many themes as we can. The first one is on the law, so it will, maybe Jo, you can have a go at answering it first. It was a very popular question. It's been voted up, saying that an issue that often comes up with flexible working is the difference between the legal right to request and the legal requirement on the employer to meet that request. But there's a big gap between these, and this is where a lot of the requests fall. Can you provide a bit of clarity on the employer's legal obligation here? You suggested that the law's not helpful, but what obligations does the employer have?
Well, as I said, the obligations on the employer are to consider the request in a reasonable manner, and you're then looking to the ACAS code to set out what a reasonable manner is. So they must consult with the employee about their request. If they're having a meeting, the ACAS code recommends that the union rep attend them with the meeting. So it'd be important to let members know. I mean, one of the things that seems to be coming out from this session is that people are often alone in making these requests for flexible working. And, people making flexible requests from working from when they've been working from home, even though we know that's not the only flexible working request, can feel quite isolated. So it's important that, unions let members know that ACAS code says that they should have a right to be accompanied, and they should, balance the employer should take into account the benefits to flexible working, not just to the employee, but if it's a benefit for the employee, it's a benefit for the business. And that's pretty much what the consultation document says. It talks about the benefits of flexible working. And, for so often, employers have sort of resisted this because they've just thought it's employees who want it. Now there is, the McKinsey report, and we can probably give you a link to that, which sets out that there are benefits to employers in terms of improving diversity within the workforce, and also in terms of financial benefits for the employer as well. So reasonable is broad. And the unions are really good at this, at sort of trying to take the employer down an avenue of what is reasonable according to what the union thinks it is, and trying to challenge the employer what the employer thinks it is. And as I said, you've got the ACAS code to help you there. And looking at what I've seen on the chat, there's also some really good practice elsewhere. So, the question for the employer is, well, why not? As soon as it was enforced, the home working was enforced, you were able to cope with it. So why can't you cope with this?
Yeah, absolutely, Jo. That is what, just like you said in the chat, where people have been sharing examples of successful situations. This is really great to hear, because we, it's all information that is helpful to us. Alice, have we got any other actual case study examples that relate to what Jo just said, where unions have been able to be more creative with their challenges to employers if requests have been turned down?
I'm sure we'd be able to dig some out and share them. I thought Jo's point around the pandemic is a really important one. For so long, employers argued that flexible working was too hard to implement. It would kind of cost too much. There were too many barriers. And yet, probably within a week, back in March 2020, around 40% of employees in the UK were working from home. So that's one of the hardest bits of flexible working to introduce, and yet they were able to do it so quickly. But I can definitely dig out some examples of kind of where affiliates have kind of negotiated different things where after flexible working requests have been denied.
Fantastic. And yeah, just to reiterate, any resources that we've referred to in the webinar, we will make sure get sent to you all, along with the link to the recording later today or tomorrow. And if we don't get to every question, which I'm pretty sure we won't, is because there's very nearly 50, we will try and answer some of them in written form back on this page over the coming week or so. So do check back. Okay, we've had a whole batch of questions about flexible working requests in relating to caring responsibilities. So can you talk a little bit more about those and maybe things that reps should look out for, particularly in relation to grandparent requests? Are there any, is that a valid caring request? And what if someone is a primary carer and their request for flexibility is rejected? What happens then? Question for both of you, but let's go to Jo first.
Right, so caring responsibilities, I think we can tie these in with potential discrimination claims where these are refused. So if for example, that doesn't matter whether it's a grandparent, a parent, or a partner or a carer, the status of the individual, so an employee and meet that, flexible work for a statutory request. But in terms of discrimination claims, so where they're a carer and they're a worker and they don't have an employment contract, or they don't have the 26 weeks continuous service, then they got better protection to the extent that they could potentially argue that the refusal means that they've got to comply with the requirement that the employer is insisting on. So I think I gave the example of where the employer says, well, I'm going to refuse a woman's request for fixed shifts because I want the ability for her to work over weekends, which doesn't suit her childcaring responsibilities. Then effectively that amounts to the employer applying a requirement that she work weekends that more women than men are less able to comply with because they've got these caring responsibilities, and that puts them at a particular disadvantage. The employer is then required to show if that is, have they got a legitimate aim for requesting that, one person can't work, everybody has got to work flexible working, and they can't accommodate maybe a few requests for fixed shifts. I mean, if it could be temporary, just while her children are at school or in nursery, for example. So there are lots of points that you could make, but the employer has got to act proportionately. So they've got to set out the legitimate aim, why it's proportionate to insist on flexible weekend working, for example, why one request can't be accommodated, usually the employer will say, well, this will set a precedent and we'll have everybody who doesn't want to work weekend working. But as we've seen, people work a variety of shifts, and all those people who've been in essential services have been doing, just that. So there are people who will be willing to work those weekend shifts, perhaps, that maybe aren't working those weekend shifts. So it requires an employer to investigate and to consider the request proportionately. If they're not considering their request, then they may be liable for a claim for discrimination, either on the grounds of sex or race. I mean, the other point, which I didn't say before, is if where somebody is caring for a child who's got a disability, for example, then they may be discriminated against because of their association and their caring responsibilities under the disability provisions. So there is, scope under the discrimination for unions to use that to try and challenge employers. And so what you want to be doing is, when somebody is making a request, thinking about, well, why is the person making a request? Is it because of their race? Is it because of disability? Is it because of age? These are all protected characteristics under the Equality Act. And then you start to think about, well, is this a reasonable, is this request? Is the employer applying a requirement on my member that she can't comply with because of a protected characteristic? And then that's how you can get into challenge on a basis of discrimination.
That's excellent advice, Jo. Thank you. Have you got anything to add to that, Alice, or shall I move on to the next set of questions?
That was an amazing answer and covered everything in so much
really
detail. The only thing I was going to add was it's worth also checking things like there's a right to leave to care for a dependent in an emergency, which you may be able to use as well if you do kind of need, if there's an emergency situation and you obviously can't get access to a flexible working request because of the 3-month period. And you also might have other policies in your workplace around carers leave and parental leave that might help out in those situations.
Thanks, Alice. I've tried to batch a whole bunch of questions together here because they cover what I'm thinking are similar themes. So a lot of people have asked about can flexible working change your employment status? This is in particularly relation to working from home. Could an employer try and change your status, perhaps lessen it at all? And what is the role of custom and practice, where there might have been an informal arrangement that then is formalised and lessened when it becomes formal? Jo, should we go with you first?
Yeah, I mean, that to me is sounding a bit like a detriment for making a flexible working request. And, there is a provision which says that an employee has a right not to be subject to a detriment by any act or failure to act by the employer on the grounds that the employee made or proposed to make an application for flexible working. So if somebody's made an application for, I think Alice gave this example, where an employer maybe refuses a request for flexible working from home on the basis that, well, you can work from home, but you can take a pay cut. That's a classic example where somebody is potentially being subject to a detriment for having exercised their right to make a request for flexible working, but that only relates to a statutory request for flexible working. Doesn't relate to a flexible working request under a policy. And then again, you're looking at whether or not the way that the person who's made the request has been treated, does that amount to less favourable treatment because of a protected characteristic and a potential discrimination claim?
Thanks, Jo. So Alice, read that. I mean, I'm sure in some of our affiliates we've got evidence of, informal arrangements that have perhaps been more beneficial. Again, is this something we can provide resources on?
Yeah, I can look into it and see if we've got any resources on it. I would say in terms of attempts to water down contracts of people who are working from home, I mean, as Jo said, that could be an example of detriment for making a flexible working request. But I also think it's just worth making the point that I mean, this applies to lots of issues in this webinar, but flexible working is hugely popular and is therefore can be quite an effective organising issue. And I think if you are negotiating for a policy where a lot of people want to continue working from home and a threat from an employer is to cut terms and conditions, it could be something kind of to organise around and use the kind of power of your membership to push back on that. We have seen a lot of threats to kind of deduct London waiting and things like that. And I'm pretty sure kind of unions have been organising around those. And it would also result potentially in a change of contract, which again, the employee would need to agree to.
Thanks, Alice. So you've both mentioned the scope that an employer has to turn down a flexible working request, and this is often the needs of the business. We've had a few questions asking, do employers have to give a lot of information about that, or can they just say the needs of the business, for example, or financial implications? So, how much information do they have to give us, Jo? And also, Alice, do you know whether unions have had this challenge across the board, and how can they share this information? Jo?
Yeah, so in terms of the information under a statutory flexible working request, the employer can just really point to one of those business reasons and simply rely on that, and then you're left with challenging it, the basis of their reasons, saying that it's incorrect facts. Now, there is one employment tribunal case, so I suppose the significance of that is just one, and it's back in 2005. And this concerned a woman who put in a request to work 3 days a week so that she could look after her granddaughter. And the tribunal upheld her claim that the employer had failed to comply with the statutory flexible working procedure. It said that the tribunal was entitled to investigate to see whether or not the employer had provided evidence as to whether or not the decision was based on incorrect facts. And here what had happened is that the employer hadn't put forward any evidence to show why they rejected the part-time working request. So it stretches the legislation a bit, because the legislation just simply says that the employer can refuse it and you can challenge it on the basis of incorrect facts. But the tribunals have been reluctant to say, well, the employer has to give us all the business reasons for it. They're not interested, and they won't ask the employer to provide their commercial reasons. But the EAT in this case suggested that when an employer is making a refusal, then some of the things the tribunal could consider would be, what would have been the effect if the application had been granted? Could it have coped with the disruption? What did other staff feel about it? And could time be made up? So those are factual things, arguably, that the employer should take into account. And if they don't, then it might be incorrect facts. But I'm just giving this as an example of how you might be able to rely on it. But I am also acutely conscious of the fact that there haven't been any other cases which have tested this point. And I think that's probably because the unions can negotiate a better resolution than having to rely on that. But it might be useful where you've got, a really reticent employer who's not willing to engage even in the debate. You can point to that decision to say, well, look, actually, a tribunal may well scrutinise it if you're not giving us any evidence as to why you've refused the part-time working request.
Thank you, Jo. So, Alice, the viewer did ask, are other unions facing this? Where how are unions getting back to management when they're told, no, you just can't do this for business reasons?
So yeah, we have heard that this is happening with certain employers, very hostile employers, not providing any reasoning, or in some cases not even replying. But as kind of Jo said, there's sort of a spectrum. So we've heard of these very hostile employers doing this, but then also kind of employers where they might not give a reason, but they might be open to a meeting to discuss the flexible working request, which I think is a helpful way for unions to try and push this forward. So demanding a meeting with your employer, with a rep and the member who's made the request, to talk through the reasoning, because it may be that there's an alternative that can be some sort of compromise between what the individual needs and the very kind of the strong business reasons that an employer feels the flexible working request isn't possible. So I think that meeting can be a really important way of trying to achieve that breakthrough, in terms of if you've got a very hostile employer who's not giving you any information. I was also going to say, we also submitted, as part of this consultation that happened before Christmas, part of the TUC's response, which was based on what affiliates kind of fed back to us, was a statutory requirement for a meeting to take place, so that it can be discussed, and for employers to have to provide some evidence as to why they think the flexible working request wouldn't work. I'm not saying we'll see what happens with those two, but they're the two things that unions are calling for when it comes to this area.
Thanks, Alice. I'm very aware it's 3 o'clock, but I'm going to put one more question in, which I think is a quick one. So, and we've not covered a question on this yet. We talked about flexible working being mentioned in job ads. What could be a way to challenge this if it's mentioned in a job ad and then it's withdrawn? So it's basically used as an incentive to get people to apply, and then it doesn't follow through. Or if I could, the hardest one to last, if I just on that.
Well, and then you sort of, if it's, so they put flexible working in and then they withdraw it.
Are we straying into false advertising here?
Yeah, well, sort of, it's misrepresentation, isn't it, really? You know, and I don't want to go into the law of misrepresentation, but it is a misrepresentation. It might be something that you'd want to draw the Equality and Equality and Human Rights Commission's attention to, because generally when it comes to adverts, an individual might not necessarily be able to bring a claim unless they can show that they personally have been discriminated against that. But it might be something that the Equality and Human Rights Commission can do, because they can challenge adverts themselves, discriminatory advertising and advertisements of jobs or discriminatory criteria. So, I'd probably bring it to the attention of the Equality and Human Rights Commission. I know that sounds like a bit of a fudge, but, without going into the law of misrepresentation and what potential legal actions there and the huge costs that are involved, it's not something that a road we want to go down. This is an issue that should be addressed collectively. The employers wanting to gain all the brownie points by putting out an advert out there, they should be outed and said, this is what they're saying on one hand and withdrawing it on the other. And that should be, that's a collective matter, I think, or better dealt with collectively.
We'd be here till Easter if we started discussing misrepresentation now, so perhaps we'll save that for another time. So we've had a huge number of questions. I reckon we've got through about a quarter of them. So I do think this might be a subject for a future webinar again. We've got people saying we need at least an hour and a half. I reckon we perhaps need a mini series, but we will try and answer in written form the questions in the Ask a Question panel below, as you see. So before we sign off, just to mention that in February, starting on Valentine's Day, it is Heart Unions Week. This is our annual celebration of everything that is great about unions, how and why they're helpful in the workplace and why people should join a union. And as always, we'd like you to tell us about your union success stories. So do please email us on tuceducation@tuc.org.uk. That email address will appear in the chat panel in a second, because we in Heart Unions Week will be doing a webinar where we hear inspirational stories from reps. We love hearing those. It's always a great motivator, and it encourages us to get out in the organised and get active. So I just need to now say thank you to both Jo and Alice for fantastic information today. We may well see them again soon to talk more flexible working and our rights around this. So thank you to both of them, and thank you to the audience. You've all been great with sharing your questions and experience with us. We'll see you again soon. Bye-bye for now.
Thanks very
Bye.
much. Bye.
Thank you. Thanks for all your contributions. Fantastic.